Hi. My question is upon Robert asked the first half of it, which is how many were approved, but I was wondering, out of those, did all of them or most of them need the state approval, and did they already have that when they came? And did they, I guess people know that? And were the ones that were not approved, were they not approved by the state or by Dunwoody?
Only a few of them required a state waters buffer variance. People generally really try hard to stay out of the state waters buffer. It's about a 6-month process to get a state waters buffer variance, and it costs about $5,000 to apply for the application and whatnot. So that's a high hurdle, and people have typically tried to avoid that. When I say it costs $5,000, that's if you hire an environmental scientist to fill out the application and make the case. Before you can certainly do it yourself for nothing. But so people, there's been a handful. There's been maybe 4 or 5 variance requests, state waters buffer variance requests. Oh, sure. Yeah.
I have 2 questions. First is, there's been a wall, a sizable wall, about 125 feet long, probably 8 feet tall, built inside the creek banks. Which entity is responsible for having the owner take down the wall? It was built without a permit. The EPD or the city of Dunwoody?
Let me repeat your question. A homeowner constructed a seawall or a retaining wall?
A wall. It's a wooden wall.
Wooden wall.
It's about 125 feet, a little bit long.
Within the state mandated buffer, the 25-foot buffer?
Oh, inside the creek bank.
Inside the creek bank.
Yes, sir.
Inside the creek, in the water itself?
Inside the water.
That would be regulated by the U.S. Army Corps of Engineers.
So, who sees that something happens to the wall and it comes down?
Pardon? The first thing you would do is, if it's in the city of Dunwoody, the city of Dunwoody is the local issuing authority, so they're going to be responsible for inspection and compliance under their ENS ordinance, their erosion sedimentation control ordinance. Someone constructed a wall, for whatever reason, inside the stream. First place is I would contact the city of Dunwoody. More than likely, the city's going to contact our office. We will try to get in touch with the Corps of Engineers. Under the State ENS Act, which I talk about, we are concerned with the buffer. The Corps of Engineers, if you fill any streams, you dredge any streams, you impound any streams, you generally need a permit from the Corps of Engineers if it's waters of the U.S. If someone puts something in the stream and it's not covered under the ENS Act, EPD or the state can also do enforcement under the Water Quality Control Act for putting pollutants into the stream. A wall may not be considered a pollutant, but we may have a way to address it through that Water Quality Control Act, not the ENS Act, and that would be EPD. But first place is always go to the city, and then they can verify if that's covered under your ordinances. If not, it may come to the state, and sometimes it may have to go to the Corps or EPA if they regulate it.
Second question. A neighbor is trying to, applied to build a room inside the flood zone and inside the stream buffer. The city did not give them a permit. So they went before the board, the appeals board, and they were granted the right to build the room inside the floodplain, inside the buffer zone. What the neighbors and I want to know is there where would we go next, or is there anywhere else we can go next to stop it?
Right. You said they built an addition to the house?
This has not been built.
They're proposing to build an addition to the house,
yes,
and it's located in the buffer. Which buffer is it located within?
Inside the stream buffer.
Okay, but let's see. We have the state mandated buffer that's 0 to 25, and then you.
This is 75.
Okay, I'll turn it over to Rich.
And yeah, the answer is that there are a couple of ordinances that are in play. One is the floodplain management ordinance, which contrary to, I guess, popularly held belief, you can build a structure in the floodplain. It typically has to be elevated. You have to show that you're not impacting the floodplain by increasing the base flood elevation, the 100-year flood elevation. If you show those things, you can build in the floodplain. Secondly, as far as the buffer goes, once the Zoning Board of Appeals has granted the variance, there is an appeals process. I believe it's the DeKalb Superior Court. If you have standing and you're aggrieved, so about their decision.
So is that 30 days? You know?
I do not know.
Thank you.
Hey, Steve Barton is my name. I just have a context question. You said that our current ordinance really was a follow-on or an enactment of what DeKalb County has. And so does DeKalb County have this extremely broad definition of a stream that just includes the places that are ephemeral? Is that where we got it? And how are they doing with it? I mean, given that where this comes from is a perception of many requests for variance because we have this broad definition of a stream, is DeKalb County, when you build there, are there many requests for variances, or do they just not pay such close attention to it? And what do our neighbors do with respect to this? And that's the context I would ask for.
When Dunwoody adopted DeKalb's buffer, I don't know when that was, but DeKalb has changed its buffer variance.
The greenest county in America?
It is operating very well, actually, because we still do have a 75-foot buffer, but the development director is the only one who has the right to grant variance to that outer 25, and he can only grant 10 feet into that buffer, so that if someone wants to build a deck or even a room addition and they show that there's nothing else that they can do, that they're that close, then that variance comes to in-house into the staff that has the knowledge to assess, any potential damage to that, and therefore it doesn't go to our Board of Appeals at all. What could go to the Board of Appeals if he granted it or didn't grant it, and someone wanted to then object to his decision, his in-house decision, then the Board of Appeals has a role. Other than that, we're operating with the Metro North Georgia, as well as the State 25, as well as DeKalb's 75. So it's working pretty well.
And this definition of the stream, though, the broad definition where we are basically regulating ephemeral stream encroachment.
But
does that apply to DeKalb County?
We have the same definition. That's the state water definition, but the state law, as well as your ordinance exempts ephemeral streams already.
No, it doesn't. That's what we're talking about.
The state waters.
Yeah, so it exempts. Yeah, it does exempt ephemeral streams. So why?
But Dunwoody's ordinance is not. Their definition of stream is.
Well, somehow we operate with the same definition that the state operates on with state waters, and our stream is defined as more or less the state definition. But citizens know that if it's ephemeral streams are not a problem, because they know that it's intermittent or perennial that they need to come in and talk about, more or less.
Dell, just for a clarification of what Steve asked, could you just point what exactly changed DeKalb County did? What has DeKalb County done differently precisely since December 2008? That's point one. And number two, exactly how does their stream variance buffer variance work? The process.
Well, the process is there's a $75 application to the development director if they want to build a deck or a home addition that goes into the outer 75, the outer 25 of the 75. If they're asking to go all the way into the state buffer, then they have to go through the same process that's been described here. They have to first go to the state, make application there, and if they get approval there, then the outer 50 feet comes into play at the local county level. But somehow, right now, I think we do have buffer variance requests, and I can't give you data about how many are denied and how many are not. But that process thus far has been successful. Now, if if someone's grandfathered in, and there are more detailed rules and regulations, if a building gets torn down, what exactly happens? And I can't sit here tonight and talk about those details, but DeKalb went through an extensive buffer variance process change after Dunwoody became a city and had adopted the old one. So y'all really do need to look at DeKalb's and decide if there is any merit in it, and not, because we no longer have, just the blanket buffer that y'all adopted. But we do use that definition.
Hey, Joe, to respond to Steve's other point about what the other communities do, many of the other communities that I see have adopted the model ordinance. And the model ordinance essentially exempts anything that any stream that has a drainage area less than 25 acres that is not showing evidence of groundwater flow from the definition, and therefore there's no buffer on anything that is essentially an ephemeral stream in the model.
Yeah.
Okay. I'm Terry Nall with City Council. I think it's on.
You're right.
And wanted to thank the panel and the participants for taking time out of your night to be here. If I may have two things. Dell, following up on what you were saying and to Steve's question, what the CAD, Steve, what they did, just to clarify that, in Dunwoody, every single stream buffer variance goes to the ZBA. That's your only avenue of recourse to get the variance. What the CAB did is they gave administrative variance rights to their director there to do certain things so that if your project fits within those parameters, you don't have to go to the ZBA. And I think that's a good thing because the ZBA process, as good work as they do, it's a very time-consuming process as well. Rich, a question for you, because I don't know the answer, and you may not just off the cuff. But of all the variances that were granted, and you said what was 18 or 19 of the stream buffer variances that were granted, how many of those were granted either with conditions or without conditions, meaning that if we didn't have the current variance process in place, that then those conditions that they applied never would have been part of the deal? And I'm assuming they wouldn't add conditions to that unless there was something about the project that they were concerned with, versus a variance of approved, no conditions whatsoever.
Yeah, I think a lot of them, I don't know the exact numbers. I think a lot of them do have conditions, but generally they are always conditioned to the site plan that's in the application. And so when the Zoning Board of Appeals makes a decision, it's looking at the specific thing that, or the specific site plan that the applicant wants to do. And so if the site plan differs somehow from that, then the variance would have to go back, through the ZBA. Essentially, staff would stop it and say, oh, this is not what the ZBA granted. This is not what you said you were going to do, and therefore you're going to have to go back before, or we can't issue a permit based on this site plan.
Okay, I have three questions in a statement, and I'll be quick. But I'd like to confirm with Mr. Carubba: was there any scientific method used when the state first established the 25-foot stream buffer back in 75, 76?
The state mandated buffers are established by your state legislators, and this was done before before I began working for the state and working in this program. I think it's safe to say that, yes, there was some scientific background when they made that decision. I was not there, so I can't verify that. But if you go through other states, they do have varying buffer widths. Some states may have 25, some may have 50, may have some 75. And you're going to have scientists, environmentalists will disagree about what is the perfect buffer width. But as Jason did point out, it's going to really vary depending on your topography, soil types, and what kind of vegetation you naturally have. But right now we have a 25-foot, that is statewide, and you have a 50-foot for you trout streams in Georgia.
All right, so thank you. And to Mr. Edinger, when Dunwoody adopted a 75-foot buffer, was any analysis made to determine what increased amount of benefits would be had by 75 over a 25?
The city did not. The city essentially adopted DeKalb's code. There are studies that have been done to show the benefits of different buffer widths, and that literature is out on the internet and pretty readily available.
All right, well, when it comes to stream buffers, I don't deny that more is better. 100 or 200 feet would be better, but has the city of Dunwoody ever considered compensating their landowners for encumbering their land with a 75-foot stream buffer?
Not to my knowledge.
The rest of my case.
My name is Dan Peterson. My question is very much similar to his, and my question was going to be, in light of the fact that you've extended the state buffer by 50 feet, what plan has the city put in place to compensate property owners? Because basically you've taken their land, and they should be justly compensated by that. I guess you've already answered that. I would suggest you put something in place to do that. And I guess philosophically, when you consider property rights and the rights of owners to use their property fully for what they deem is correct, to what extent? What is the priority of the city? Is it to increase this thing called sustainable development, or is it to protect the liberty of private property owners so that they have the freedom to use their property? That was the foundation of our country, and I'd hate to see that eroded, in the name of sustainable development here too. Is there a priority there for the city?
With all fairness, I'm Lynn Deutsch. You're good.
It's on.
Okay, thank you. I turned it off. I'm Lynn Deutsch, and I'm a council person, and in all fairness, that's not necessarily a question for our staff. That's a policy question, and that's why we're having these discussions today and revisiting. You think, okay, well, you want to
want to point out the other side.
Well, no. I think it's fine to point out the other side, and that's why we're having this.
There's nobody up there on the panel that's on the other side.
Right, but they're not policy makers.
Right.
The home builder. The home builder guy would probably have a perspective, but I just right. So he can give a perspective. I just hate to put our staff on the spot.
Well, if y'all don't mind me jumping in on the spirit of that, again, my name is David Ellis, and I think one thing that we can all agree on, I'd hope in this room, is that we want to do the best we can to make sure that we do right by the environment. And yet, to balance that very specifically with some of the concerns those guys mentioned, with the rights of people to use their property, which is actually a right that's guaranteed in the Constitution, or at least amendments to the Constitution, the Fifth Amendment. And but more than that, too, I think something I wanted to mention in this process, too, is trying to create a predictable and reasonable process for people to be able to do things in the city of Dunwoody. When somebody's family grows, and by the way, people are staying in their homes longer, and they say, hey, I want to add on to my house, to have a predictable and a reasonable process where they can go through that. And of course, as many of you know, many of the houses that were built in Dunwoody were built before we had the consideration of stream buffers, and many of the houses already encroached on the 75-foot buffer. And so it's a really difficult thing, and I compliment the folks on the council for taking the time to really look at this and see the impact that it has. But so many of the contractors, because I work for the association, I don't pull the permits, but I talk to a lot of the contractors who work with the homeowners and talk about the process itself, and that it's painful and sometimes quite expensive to go through that variance process. And if the city could find a way to either create some more predictability, create some staff flexibility in dealing with it. And again, I go back to when they were talking earlier when it was Jason was talking about it. Really, the stream buffers were established more on political lines, I think, than on scientific lines. And if we really wanted to get into the discussion, we would create a stream buffer ordinance that actually had a wide variety of options based on the slope going down to the stream and everything else related to it. But I'm not sure any of us are smart enough to figure that one out. Or would it be even better for the consumer in the end, because it would be so, it would be a phone book of regulations people would have to deal with. So finding something reasonable that protects the streams, I think, is very important. And at the same time, to balance that with people's property rights, it's a challenging thing. But yet, in the end, I think we should be very cognizant of people's ability to use their land as they move forward.
Yeah, the other thing I would add to that is that the city is really bounded by what the state has required of it, and so the state has essentially said you must adopt an ordinance at least as stringent as the Metro North Georgia Water Planning District, and if you want to be a local issuing authority, you must adopt the erosion and sediment control ordinance, the model ordinance, and then make plans to enforce that. And so the city is somewhat constrained, in what it can do. I shouldn't say that exactly. I mean, the city council can repeal those ordinances if it wants, but there are consequences to doing that. The consequence of repealing the erosion and sediment control ordinance is that then the State Environmental Protection Division will take over the enforcement of the state erosion control law in Dunwoody. The consequences of repealing the Metro North Georgia Water Planning District or the ordinance that we have in place, the city stream buffer ordinance that's at least as stringent as that, is that we could lose our status as a local certified local government, and therefore we would not be able to get grants and loans, for infrastructure projects and that sort of thing. So there's consequences to going below some of these minimums that the state has mandated.
I apologize. I did come in 24 minutes late, so you can throw a tomato at me if this was already asked. What is the situation with grandfathered situations, structures, and things that may exist in that current? I mean, most of us live in homes here that are. Many of these subdivisions were built in the 60s when there, wasn't anything there. So if you have a structure on your land, or in my neighborhood, I actually know a couple of people that have septic tanks in this buffer. What is the situation? I mean, what happens with that? Could you be turned in? Is there going to be a buffer police running around, knocking down your structure? What's going to happen?
Well, there are. If you have and this goes for any structure that is contrary to the city's current code, but perhaps met the current code that was in place at the time that it was constructed. That's called a legal non-conforming use. And so essentially, your use is legal, but it doesn't conform to the existing ordinance. Okay, and so if you want to do something different that does not comply with the current ordinance, you have to meet the current ordinance's requirements. Okay, and so that's why when people want to build onto their home, if their home is already in a buffer, they have to get a stream buffer variance for that.
But my understanding too is, say your house burns down, and you say, "Gee, I want to build my house back." The footprint that you had initially of your house, although again not being a non-conforming use, you'd still have the right to rebuild your house within that footprint, correct?
Yeah, that's correct.
Or I guess same if your house was 50 years old and you said, "You know what? We're going to knock this sucker down and build another one." You could rebuild on that same foundation.
Yeah, you can do normal and customary maintenance to your home.
Everything that's existing.
Right. Anything that's new, any addition that would come into play.
Just a curiosity too. Say I have a deck on the back of my house. And it was there before. Now it's gotten old and rotty, and we're going to tear that thing down and put another deck on. Does that fit, or do I have to go through a variance process for that new deck?
Yeah, I think as long as you're doing maintenance, then it fits under that that legal non-conforming use. But if you want to remove it and put something new in place, then that falls into you have to bring that up to code, up to the existing code at that point.
Okay. My name is Tom Dwyer. I'm with Harbortown Construction. I'm a licensed residential remodeler and light commercial builder here in the city of Dunwoody. I'm also here to represent the National Association of the Remodeling Industry, who asked me to come here and look in on this. And for the input portion of the meeting here today, I'd like to suggest to the council and people that are in charge that as remodelers, we would like to see some uniformity of enforcement across the whole North Metro region, because every place we go to pull a permit, I don't just work in Dunwoody, is different. And so if the North Georgia ordinance is the one that's recommended, I'd like to see that become the model and not something more restrictive. I'd also like to see in place what DeKalb County has in terms of 10-foot or a 10% administrative variance, not only just for stream bank buffers, but for those additions that we're trying to build that just maybe slightly encroach the various lot setbacks. And so that would mean that we would have a 50-foot buffer. And also just a suggestion that maybe even could be written into the code and put on the site plans, is in Georgia, it's typical for the driveways to be built like an open sewer, convex, to keep the water on the person's property, rather than concave, where the water would flow off into the lawn and the natural areas. Instead, it's running into our streets and curbs and into the storm gutters and causing quite a problem. So I'd like to see that addressed as part of the building department stuff. And lastly, I'd just like to say that as a licensed contractor, and as the builders are required, we have to get a level 1A fundamental certification in order to do land disturbing activities. So in order to build an addition, you have to have that certification as a builder or remodeler. And I'd just like to tell the homeowners that rather than being unaware, like the DeKalb person mentioned, and possibly having to tear something down, that it would be good to be looking for qualified builders and remodelers that have that certification, and somebody who's going to be conscientious enough to do the right steps, and know that in order to do this, you're going to have to get probably a survey that's going to be $1,000 or $1,200 to pull your permit, and if you have to do the variance process, it's going to cost you some more money. Thank you.
As a note, there are brochures on the back table that describe the certification program that was just mentioned. There's a level 1A, level 1B, and a level 2 certification level.
And again, I'm glad you mentioned that, Tom, and I'm thank you too, because one of the things you have to realize is that every contractor now has to go through that certification process. And it's done a lot, I think, to raise their sensitivity to runoff and how that works, and they understand silt fences now. You see a lot of job sites where you never saw silt fence before. There's silt fence, it's regulated, it's watched. When construction is being done now, it's a much more healthy process, and runoff is, when it's of course done properly and maintained properly, it's a much better process for construction and much safer for the streams.
Yeah. Okay, there.
Hello, I'm Connie Weathers from the Sustainable Norcross Commission, and I wanted to speak to the comments the gentleman had about the other side of the story, and that perhaps there was no one at the desk that could present the other side. I just want to remind you that there are several other sides, and one of the other sides is the property rights of the homeowner who is downstream from the area for whom the stream buffer request, variance request, is being made. Unfortunately, everybody lives downstream of something, and sooner or later you can be the victim, I might say, of unscrupulous development upstream of you. and your rights are not nearly as well protected as one of those victims. I think it even says in the state information that evidence of erosion and flooding is not sufficient to prevent the variance from being given. So I just want you to keep an open mind as you're discussing your possible changes in your ordinances, that those people who are downstream do have property rights as well. Thank you.
And I think where that comes into play too, or at least the argument that would follow that, would be if the downstream rights of all are part of the public good, and you're going to tell someone upstream they can't use their rights, their property, as an impact on the public good, that person might potentially be compensated for their inability to use their land for a right that was taken away for the public good.
Is this on? My name's Norm Leahy, and I live in Winter Creek, so I'm sure there is one there. It's not on my property, it's down the street. Would it be wise for people who live down the street and have that creek running through their backyard to go down there with a little vial and take a sample of water and take it someplace and find out what the hell's in it? Would that make any sense? Would that be helpful? Would that help avoid fees and application fees and impact fees?
Well, I can speak briefly. There is the Georgia Adopt a Stream program, which trains citizens and provides them the tools to collect water samples and analyze them in your own homes to track for chemical pollution and bacterial pollution. So you can track to see if there are leaking sewer septic systems in your community or leaking sewer lines. They don't track specifically sediment, which is what we're most concerned about with a lot of these development cases, but there are programs allowed or available if you are interested in taking water samples and testing them through the state.
Well, if there are many ways to make a buffer zone, then how do you measure what's effective unless you take a water sample and compare one to another?
Yeah, we say that the stream buffer really is a measure that addresses non-point source pollution. This is pollution that essentially is running off from impervious surfaces. It's many times sediment. It's maybe oil that drips out of automobiles. The kind of pollution that I think you may be talking about is something that could, if you found it in the stream, that you could trace it back to a particular source. That's called a point source of pollution. And so those are regulated under a different program than what we're talking about here. But I mean, if you wanted to take a water sample and have it analyzed, the city, by the way, does this. They have a dry weather screening program where they, every year under their municipal separate storm sewer system permit, they go out and they sample they do a dry weather sampling, which means they wait until a dry period, and then they sample outfalls where they find flows, and they analyze it for a list of different contaminants. They find those contaminants in there. They try to trace it back to a source, and when they find the source, then we either we can address it through a code enforcement program, or we point it out to the owner, and then they have an opportunity to repair whatever the problem is.
Is what we're really trying to measure here sediment, and that's it?
Sediment is the pollutant that they are trying to regulate.
Okay.
Yes, under the non-point source program in Georgia, sediment is a surrogate pollutant. And what that means is that it's a pollutant that essentially is a surrogate for all the others. So if we can minimize the amount of sediment in our streams, we also minimize many of the other pollutants that run off impervious surfaces.
Any other?
My name is Carl Franklin, and I'd like to kind of piggyback on what this gentleman asked about, isn't it true that the government has confiscated land by these guidelines and haven't compensated the people for their land.
Sir, if I could just interject, these are subject matter experts in their field, so if you want to address one of their field area subjects, that could be appropriate.
Well, when you have these guidelines, what I'm asking is it true that the government has used these guidelines to actually take land from individuals and not compensate them?
Well, that's what zoning is.
No, I just question. Isn't it true? I mean, isn't it true?
Sure.
Without compensation. I just think everybody should know that.
Are there any other questions from the audience? I thank you everyone for coming out tonight. I want to make a couple quick notes on the website. Now, this is all going to dovetail. Rich mentioned the zoning code rewrite.